Sorry. All right, we'll go on the record. This is and cause number 46038. Today is September the 4th. It's approximately 9:05 in the morning. Ms. Hennigan, please call your next witness.
Thank you, Your Honor. Duke Energy Indiana calls Kathy Lilly.
I see Ms. Lilly's already at the witness stand. Ms. Lilly, if you would please remain standing, and would all other witnesses who intend to testify today please stand if you're able, and then raise your right hand to be sworn. Do you swear or affirm the testimony today that you will give will be the truth, the whole truth, and nothing but the truth? Great, thank you. You may put your hands down and please be seated. Ms. Lilly, have a seat. And Ms. Hennigan, when you're ready.
Thank you, Your Honor. You want to pull that nice and close. Is it on?
It is now.
Thank you. Good morning, Ms. Lilly.
Good morning.
Do you have before you what's been marked for identification purposes as Petitioner's Exhibit 5, your direct testimony in this proceeding?
I thought I had a amended.
The cover sheet will be the same, but the changes have been made inside.
Thank you. Yes.
Do you also have before you what's been marked as Petitioner's Exhibit 31, your rebuttal testimony?
Yes.
Thank you. With that, Ms. Lilly is available for cross-examination.
Thank you, Ms. Hennigan. Block LLC, not present. Citizens Action Coalition.
Thank you, Your Honor. Good morning, Ms. Lilly. How are you?
Fine. Thank you.
In the upper right-hand corner of the desk, the court reporter has placed 2 documents in front of you. Could you please look at those? The white document should have a label on it that says CAC-CX5. Do you see that?
Yes, I do.
The first discovery response here is Duke's response to OUCC data request 5.3. Do you see that?
Yes, I do.
Do you recognize this data request response?
I have seen this response, yes.
Did you help prepare the response?
I don't believe I did.
Did you reviewed the response?
Yes, I have reviewed the response.
And this is about the subject matter of your testimony.
I don't believe I testified to the insurance proceeds.
Let's move on to the next document, or the next page. OUCC 5.4, are you familiar with this response?
I have seen this, yes.
Okay. And the following page, 5.06?
Yes.
And the following pages, response to CAC 8.4?
Yes.
And you did testify, going back to 5.03, you did talk about the ECR trackers in your testimony, correct?
I did testify to the ECR tracker changes, yes.
Okay, thank you. Looking at the green document, please. This is an attachment to the last page of the white document. It's labeled as CAC CX 6C. Do you see that label in the top corner?
Yes.
Do you recognize this spreadsheet?
Yes.
Your Honor, I would move for admission what's been marked as CAC CX5 and CAC CX6C.
That was CX5 and CX6C, is that correct?
Yes, Your Honor.
Duke, any objection?
No objection, Your Honor.
City of Westfield,
No objection.
Duke Industrial Group,
No objection, Your Honor.
Kroger Company. Not present. Nucor Steel,
No objection, Your Honor.
River Ridge Development Authority, River Ridge Property Owners Association, Rolls-Royce.
No objection, Your Honor.
Sierra Club, not present. Steel Dynamics, not present. Wabash Valley Power Association, not present. Walmart,
No objection.
OUCC.
No objection.
Citizens Action Coalition's exhibits CX5 and CX6C are admitted into the record without objection. Ms. Washburn.
Thank you, Your Honor. We have no further questions.
City of Westfield, any cross?
No, thank you, Your Honor.
Duke Industrial Group,
Thank you, Your Honor. Good morning, Ms. Lilly. I'm Todd Richardson, representing the Industrial Group.
Good morning.
In your direct testimony, you address recovery of coal ash residuals compliance costs. Do you recall that?
Yes,
If we call those coal ash costs, is that a convenient term to use?
I can deal with that.
Okay. And do you recall that recovery of certain categories of those coal ash costs were addressed in 2 recent appeals?
Yes,
There was a Supreme Court decision in 2020, Indiana Supreme Court decision in 2022, and then an Indiana Court of Appeals decision in 2023, correct?
sounds correct.
Yes. And am I correct that in this rate case, Duke is foregoing further efforts to recover the costs that were addressed in the 2022 Indiana Supreme Court decision? Is that right?
That is correct.
But that's not the case with respect to the 2023 Indiana Court of Appeals decision, correct?
That is correct.
Okay. Do you recall that the Court of Appeals decision related to a subdocket, the S1 proceeding arising out of Duke's last rate case?
That is correct.
Yes, and in the S1 proceeding, Duke was seeking a CPCN under the federal mandate statute with respect to coal ash costs incurred starting in 2019. Is that right?
For a subset of ponds, yes.
Okay.
I'm sorry, Ms. Lilly, what was your answer? I couldn't hear you.
I'm sorry, for a subset of coal ash ponds, yes.
Thank you.
The commission granted the CPCN as requested, right?
Yes, that is correct.
But the Court of Appeals reversed with respect to costs that were incurred prior to the order date of November 3rd, 2021. Do you recall that?
Under the federal mandate statute, yes.
Okay, thank you. So based on the Court of Appeals decision, the CPCN that was granted in the S1 proceeding is no longer effective with respect to costs incurred prior to November 2021. Can we agree to that?
Can you restate that question? I'm sorry.
Yes, there was a CPCN that was granted by the commission
Yes,
that covered the 2019 through October 2021 period, as well as November 2021 forward to a point in time, correct?
correct.
And the Court of Appeals reversed with respect to the pre-order costs, correct?
Correct, under the federal mandate statute, yes.
Yes. And so the federal mandate, CPCN, is no longer effective with respect to costs incurred prior to November 2021, correct?
That is my understanding, yes.
Okay. In this case, Duke is seeking to recover those costs, and help me if I get the terminology wrong, as part of the cost of disposal that's reflected in depreciation rates, is that correct?
It is included in the depreciation rates, yes.
Okay. In Duke's last rate case, cause number 45253, did Duke seek recovery of those costs through depreciation rates?
I'm not sure I completely understand your question.
The relief that Duke is seeking in this case would recover the coal ash costs at issue in the Court of Appeals decision through depreciation rates,
I
correct?
did not have coal ash in the depreciation rates in the last
Okay,
case, yes.
okay, that answers the question, thank you. Was there any other proceeding in which Duke received pre-approval from the commission for recovery of the costs that were addressed in the Court of Appeals decision?
I believe the rate case prior to that had coal ash costs included in the depreciation study.
Okay, and did that encompass the costs that were addressed by the Court of Appeals, the 2019 through November 2021
I would say a
costs?
subset of those, yes.
Okay. You testified in the ECR 39 proceeding, did you
Yes.
not?
I did, yes, I did.
And do you recall submitting supplemental testimony that specifically addressed the impact of the Court of Appeals decision?
Yes, I do. Remember that
Okay,
vividly.
thank you. Yes, as do I. Do you have before you what's been marked as IG CX5 and CX6? You might not.
I do not have IG.
Could I ask the court reporter, we marked 4 cross exhibits. If we could put those in front of the witness, I would appreciate it.
We'll go off the record while that's accomplished.
Thank you, Your Honor.
Thank you.
Let's go back on the record.
Thank you, Your Honor. Ms. Lilly, do you see before you what's been marked as IGCX5?
Yes,
And do you recognize that as a Duke discovery response that was submitted in connection with the ECR 39 case?
it's been a heartbeat since I've looked at it, but that appears to be correct, yes.
And if you look on the second page, you're identified as the responsive witness.
I see that, yes.
And if you, could you also see if you have in front of you what's been marked as IGCX6?
I do.
And similarly, that is a Duke discovery response in the ECR 39 proceeding in which you're indicated as the responsive witness, correct?
That is correct.
And I think you'll see that the 2 requests relate to the coal ash costs incurred by Duke prior to November 2021. CX5 relates to the 20% deferral, and CX6 relates to the 80% that was being tracked. Do you see that?
It appears that is correct.
Okay. And as reflected in subpart A of those 2 discovery responses, am I correct that as of the time of the ECR 39 order, the costs, the coal ash costs for the period from 2019 through October 2021 were not being held by Duke in a regulatory asset?
Yeah, I don't recall the exact date of the order of 39, but that appears to be correct, yes.
Okay, thank you. Am I correct that in December of 2022, as indicated in subpart B of those 2 discovery responses, Duke recognized an impairment for those costs?
Yes, that's what the response was, yes.
Thank you. Moving on to another subject. Do you recall in your direct testimony, you noted that Duke is expecting to retire Gibson Units 1 through 4 earlier than the date assumed in the depreciation study?
Yeah, can you tell me where that is in my testimony, please?
Yes, direct testimony pages, starting on page 21, and it goes on for, I think, a couple of pages.
Yes, thank you.
You recall that testimony?
Yes,
And you indicate there on page 22, do you not, that Duke is proposing to extend the retirement date for depreciation purposes beyond the time when those units will likely remain in service. Is that right?
that is correct.
Okay. And I think you indicate that that treatment will have the effect of mitigating the rate increase with a view toward customer affordability, right?
That is what my testimony states, yes.
Okay, thank you. With regard to, and I'm going to contrast that with the Edwardsport plant. With regard to the Edwardsport plant, do you recall that in the Duke's 2021 IRP, the preferred portfolio anticipated retirement of the gasification equipment in 2035 and continued operation on natural gas until 2045? Does that sound familiar?
I wasn't really involved at the IRP, so no, I cannot confirm nor deny that.
Okay. Do you recall that currently, in this case, Duke is projecting 2045 as the retirement date for the Edwardsport plant?
I believe that was in Mr. Luke's testimony, yes.
Okay. Is Duke proposing to spread the recovery of the Edwardsport investment through depreciation rates through the retirement date of 2045 in this case?
I think that would be a better question for the depreciation study witness.
Okay, you don't know one way or another?
No, I do not know.
Okay. You don't recall that Duke is proposing to accelerate the retirement date of, or excuse me, I should say accelerate the recovery for the Edwardsport investment to 2035 as if the entire plant were being retired in 2035? You don't recall that?
I think, again, that's a better question for the depreciation study
Okay.
witness.
Okay. In your rebuttal testimony at page 14, do you recall indicating that Duke is entitled by statute to full recovery of its capital investment in Edwardsport?
Yes, that's in my testimony.
And you base that on a statute that is quoted, Indiana Code Section 8-1-8.5-6.5, correct?
Yes, that's in my testimony.
Could I ask you to look at the two exhibits that have been marked as IGCX 7 and 8? I believe they're before you.
Yes, I see them.
And can we agree that those two discovery responses relate to your rebuttal testimony that I just pointed out?
I believe that is correct.
As indicated in subpart A on IGCX 7, is it correct that the capital investment above the estimate of costs approved by the commission as updated through the ongoing review process related to Edwardsport is not within the scope of the CPCN protection under Indiana Code 8-1-8.5?
Well, again, as the response says, I am not an attorney, so that is the response here on the piece of paper, yes.
Thank you. And with respect to IGCX 8, subpart B, is it correct that the Duke response indicates that depreciation of rate base is governed by Indiana Code Section 8-1-2-19 and not by Indiana Code Section 8-1-8.5-6.5.
Again, prior to that, it says, I am not an attorney, so I did not have these responses, but that is what it's stated on there, yes.
Thank you. And before I forget, I would like to offer into evidence IGCX 5, 6, 7, and 8.
Duke, any objection?
No objection, Your Honor.
Citizens Action Coalition,
No objection.
City of Westfield,
No objection.
Kroger Company, Nucor Steel,
No objection.
River Ridge Development Authority, River Ridge Property Owners Association, Rolls-Royce,
No objection.
Walmart,
No objection, Your Honor.
OUCC,
No objection, Your Honor.
Industrial Group Exhibits CX6, CX7, and CX8 are admitted into the record without objection. Mr. Richardson.
Thank you, Your Honor. One last subject. I did offer CX5 as well. I'm told that that wasn't mentioned.
I did not reference CX5. Industrial Group CX5 is admitted into the record without objection as well. Thank you.
Thank you for that. Thank you, Aaron. One last subject, Ms. Lilly. In your direct testimony, starting at page 30, you indicate, do you not, that Duke is seeking to roll into base rates its investment and depreciation for TDSIC projects to the extent they are in service by the end of the test year. Do you recall that?
That is correct.
And that includes projects from both Duke's first TDSIC plan as well as what's referred to as Plan 2.0. Is that right?
That is correct.
You're aware, are you not, that the commission order approving Plan 2.0 is currently on appeal?
That is my understanding, yes. Waiting for an opinion, yes.
Yes. And it's currently pending at the Indiana Supreme Court. Do you recall that?
That is my understanding, yes.
Okay. In your rebuttal testimony at page 11, lines 17 through 19, you suggest, do you not, that the only question before the Supreme Court relates to the eligibility for TDSIC treatment and not inclusion in rate base in a general rate case. Is that right?
That is my rebuttal testimony, yes.
Okay. Are you familiar with the legal issues that have been raised in the pending appeal?
I am aware of them, yes. I'm not a guru on them, no.
Well, are you aware that the approval of specified projects in the 2.0 plan are being challenged under the cost justification provision in the TDSIC statute?
It was my understanding a subset of projects were under the appeals, yes.
Okay. Do you happen to recall specifically there are 90 projects at issue that account for about $250 million out of Duke's $1.2 billion Plan 2.0?
I don't have that in front of me. I do not know.
Okay. Too much detail. Let me ask you this. If the Supreme Court ultimately reverses the order and finds that the specified challenged projects were not properly approved because Duke failed to show cost justification, is it your view that that ruling would have nothing to do with the recoverability of costs for those same projects in this rate case?
That is my rebuttal testimony, yes. It would not affect the rate base in this rate case.
Okay, and is that your view? That's your opinion?
That is my understanding, yes.
Okay. You're familiar with the TDSIC mechanism, are you not?
I am familiar, yes.
Can we agree that grant of commission approval for a TDSIC plan has the effect of pre-approving the planned investments for recovery and rates?
Yes.
Okay. It's a pre-approval mechanism, is it not?
For recovery, yes.
And if the Supreme Court reverses the approval for those 90 projects that I mentioned, then for those specific projects, is it the case that Duke would no longer have the benefit of pre-approval, correct?
Under the TDSIC statute, yes, there would be no pre-approval.
Okay. With respect to the challenged projects in the appeal, did Duke submit any additional evidence in this rate case to demonstrate that those investments were cost justified?
I am not aware of any, but I'm not saying there wasn't any. I am not aware of any.
Okay. Is it your opinion that Duke's investment in those projects would roll into base rates automatically, regardless of whether they're cost justified or not?
Again, I don't know the specifics of those projects, but there was a reason that we had to do them. So I would say they would be rolled into the rate base, yes, in this case,
Okay.
if they were in service by the end of our test period. Not all of those projects would be in service by the end of our test period.
Understood. But for those that are in service by the end of the test period, your opinion is that whether they're cost justified or not, they're recoverable in base rates.
Yes.
Okay. Thank you. No further questions.
No cross,
Ecor
Your
Steel,
Honor. No cross, Your Honor.
River Ridge Development Authority, River Ridge Property Owners Association, Rolls-Royce,
No questions, Your Honor.
Walmart,
No questions, Your Honor.
OUCC,
Thank you, Your Honor. Good morning, Ms. Lilly.
Good morning.
Mr. Richardson kind of poached on my questions a little bit, so I'm going to follow up with a few things that...
Ms. Hitz, please ensure that you're speaking directly into the microphone. Don't believe you're being picked up. Thank you.
My apologies, Your Honor. You mentioned, let me make sure I've got my notes. Mr. Richardson asked you about the coal ash cleanup costs and whether or not it had been recovered as depreciation in the last case. And if I understand your response, you said that it was included in the previous rate case. Are you referring to 42539, the case before the last rate case?
It was the case before the last rate case. I do not recall the cause and number.
Okay. But Duke specifically asked for the costs from 2019 to 2021 in cause number 45253, correct?
No, that's not my understanding. In the last rate case in 45253, we had costs through we had costs included through 2018.
Okay, let me restate that. There was a subset of costs that was split out into a subdocket. Do you recall that?
That is correct, in the subdocket, yes.
All right, so in the subdocket, Duke was requesting specific approval for those costs incurred between 2019 and 2021.
That is correct, in the subdocket, yes.
Okay. And then subsequently, the Court of Appeals overturned the commission's grant, and Duke was told that it could only recover costs from the date of the commission order, November 3rd, 2021, forward.
Under the federal mandate statute, that is correct.
Okay. And as you discussed with Mr. Richardson, the CPCN that the commission granted was overturned by the Court of Appeals.
I don't remember the exact wording, but a portion of the CPCN stayed in effect. So they didn't overrule the entire CPCN.
But it was overturned as to the costs, the $92 million that Duke now wants to recover through depreciation. Is that correct?
That is correct, under the federal mandate statute.
Under the federal mandate statute. Could Duke have requested that $92 million as depreciation in the last rate case?
We could have included coal ash closure and maintenance in the last rate case under depreciation, yes.
After the Court of Appeals overturned the 2019 to November 2nd, 2021 costs as being not allowed under the federal mandate statute that was in effect at that time, Duke had refunded amounts that were collected between the commission's order and the Court of Appeals order, correct?
Within the ECR filings,
Yes.
yes, that is correct.
And those ECR refunds, as I understand it, may be still going on through the current ECR amount.
I believe those refunds go through the end of this year. I'd have to confirm that, but that sounds appropriate.
So having refunded that amount, now Duke is seeking to recollect that same amount, is it not, by including it in depreciation?
We are asking for recovery through depreciation, yes.
Was there a subsequent order by the Court of Appeals or any other court that reversed the decision, saying that Duke could not collect that $92 million?
I'm not sure I understood your question, sorry. Try me again.
Has there been a subsequent court decision that reversed the Court of Appeals?
Not that I'm aware of. Under the federal mandate statute, no.
Is Duke relying on the 2023 change to the federal mandate statute for the basis of its request that it recover the $92 million through depreciation?
I think that's a better question for Mr. Riley.
I will certainly ask him. What about the changes to Indiana Code 81210 and 19, which refer to accounting and depreciation? Are those the statutes that Duke is seeking recovery under?
Again, I think that's a better question for Mr. Riley.
Now, in your rebuttal, page 16, line 13 through 19, you discussed there that in response to the OUCC's data request 24.2, the company has not yet made the entry to debit accumulated depreciation for the amount of CCR remediation costs. And at line 17, you say, that entry would be made upon issuance of an order in this proceeding, and it will not be reflected in the step 1 net original cost rate base. Do you see that there?
Yes.
And then page 17. It will, however, be reflected in the step 2 compliance filing. Do I understand your testimony there to say that there is not yet before the commission a document showing the rate impact of that $92 million in the accumulated depreciation?
We did not do a pro forma for the $92 million, so it is not included in our net book value today in our rate case.
So the OUCC and every other party in the commission won't know what that impact is until if the commission approves your request here, it then gets included in step 2 rates. Is that correct?
I'm not sure I'm following, sorry. Try again. Can you restate your question, please?
I can try. So if there is nothing in the record currently, then the public, the commission, all the parties will not know what the rate impact will be of that 92 million until if the commission issues an order granting your request. Is that right?
Well, I believe the step 2 rates would be implemented on the lower of actuals or projected. So if we were within our projected, it would still be in our rate case today.
Thank you, Ms. Lilly. That's not the question that I asked. I asked,
Apologize.
no, that's all right.
I'm trying. Can you ask your question again,
I can certainly try and make it clearer.
please?
You've stated that there is currently nothing in the record showing the rate impact, the pro forma impact of that 92 million in accumulated depreciation. Is that correct?
That is correct. There's no pro forma today in the rate case. That is correct.
So given that there is nothing in the rate case, that means that all parties to this proceeding, the commission, the public, will not know the rate impact of that 92 million in accumulated depreciation until after the commission issues an order, assuming that the commission grants your request. Is that correct?
Again, I'm still struggling with your question. The rate impact for the 92 million would depend on where our forecasted net book value is at the end of the 2025 period. So I cannot answer that until I know what our rate base is at the end of 2025.
So I think you just answered my question indirectly. You do not know what the rate impact of the 92 million in accumulated depreciation will be at this point. Is that correct?
I would assume, yes. I don't have the information to make that calculation today.
And you don't have that information, and neither do any of the parties in this.
That is correct.
And the commission does not have that information.
Objection. Ms. Lilly has already testified that at the time of step 2 rates, rates will be implemented based on the lower of actual or projected. So that information, I believe she's already testified, is in fact in this rate case.
Ms. Hitz?
What I'm trying to get at is, yes, it will be the lower of actual, but that we do not know what the impact of that 92 million in accumulated depreciation will be until after the commission issues an order. That there's nothing in this rate case right now that shows that.
Ms. Finnegan?
I believe the mechanism through which we are implementing rates, it will be the lower of actual projected. So I believe it is in the record now.
The objection's overruled. Ms. Hitz, please continue.
Thank you. So if someone were to look for that 92 million in this rate case, would it be reflected in any work papers?
I believe the 92 million is reflected in work papers of the depreciation study witness.
Mr. Spanos?
That is correct.
Thank you. We can turn to your direct testimony, page 17, line 7. And there you're talking about the commission's order on remand, and that was as a consequence of the Supreme Court decision, was it not?
That is correct.
And you say there that amortization and return on a small regulatory asset amount, and I'm skipping to line 7, was, you say, adjusted for the commission's order on remand. That is actually, it was reduced for the commission's order on remand. Is that correct?
It was reduced, yes.
Thank you. I have nothing further. Thank you, Ms. Lilly.
Duke, can you redirect?
No, Your Honor.
Okay, Ms. Lilly, you are excused from the witness stand. Duke, go ahead and call your next witness, and then as that person's approaching, we'll go off the record.
Petitioner would call Sean Riley.
Mr. Riley, please approach the witness stand. We'll go off the record.
Does he have his?
Mr. Riley, have you been sworn?
Yes.
Okay, thank you. We'll go back. We'll go back on the record. Duke, when you're ready, please proceed.
Good morning, Mr. Riley. Can you please state your name and business address for the court reporter?
Sean P. Riley, PricewaterhouseCoopers, Seaport Boulevard, Boston, Massachusetts.
Mr. Riley, I believe you will find on the table in front of you 2 documents which have been marked by the court reporter, one of which is Petitioner's Exhibit 13. Is that your pre-filed direct testimony in this case?
It is.
And do you also have before you what's been marked as Petitioner's Exhibit 38?
It is.
And is that your pre-filed rebuttal testimony in this case?
It is.
Mr. Riley is available for cross-examination, Your Honor.
Citizens Action Coalition.
Thank you, Your Honor. We have no planned cross, but if we could please reserve the right to cross should something arise. Thank you.
City of Westfield.
No cross-examination, thank you.
Industrial Group.
No cross, Your Honor.
Nucor Steel.
No cross, Your Honor.
River Ridge Development Authority, River Ridge Property Owners Association, Rolls-Royce.
No questions, Your Honor.
Walmart.
No questions, Your Honor.
OUCC.
We do have cross, Your Honor, but given the time, I believe you indicated, the bench indicated it would be breaking at 9:50. Would
Right.
perhaps be a good time to break and not start Mr. Riley's cross and then have to stop it.
All right, with that, we'll go off the record here momentarily. Council would ask that if anyone has any cross-examination exhibits that have not yet been marked that you plan on using today, now would be an opportune time to do so. We'll go off the record until 10:15. Thank you, Council.